We've had a great week so far. This is our RAL week, and so we appreciate the turnout. RAL stands for Rural Advocacy League, and but really what our main purpose and goal is to bring awareness to rural issues that exist in Montana, how they affect the rest of the United States, how issues in the United States then affect Montana, so kind of a cycle that goes along with that. So this is our RAL week, and we've had a couple, we'll have a couple of panel discussions. We've had one on, we'll have the eminent domain one, which is tonight, and then we will have an irrigation lunch discussion tomorrow as well. So Megan's going to do a little more introduction.
Yeah, I just want to make a quick word. We did have another panelist. Her name was Brianne Johnson, and she's actually from Lund Law. If you ever heard of Hertha Lund, she's an associate there. And she had a filing deadline, so she couldn't make it tonight. So she sends her sincerest apologies. And then if you saw at the end of the row up there, there was some documents. Those are actually documents she wanted to provide to everybody here. So those are her documents. And Debbie will say a quick word about those, one of our panelists. And then if you are a lawyer here and you want to get CLE credits, at the end of that row is also a sign-up sheet. And then there's a survey if you'd like to fill that out. Now let Steve take over.
Okay, my name is Steve Brown, and my job is to introduce the panel and give just a little bit of background on eminent domain. You guys who have taken property law, you probably already know this, and you probably know it even better than I do, and these guys who have been involved in some of these cases are going to tell you some about it. But basically, eminent domain is something that's not new. It's been around for a long, long time, and the whole concept is it started out being the government can take property for public use as long as they pay for it. And if, one of the questions is, one of the big questions in eminent domain is what exactly is public use, because that's the limit to what the government can do. The other thing that's controversial about eminent domain is the power to take private property can be delegated to private parties. And that is done differently in different states, but what is going on right now in Montana is, and especially if you think about wind energy, Montana generates and has the potential to generate a lot more electricity than we can use in Montana. And so in order to do that, people want to get the electricity out of state, and in order to get it out of state, you have to put it on transmission lines and get it out of state. Well, Montana has a bottleneck where there's not enough transmission to get electric power out of state. And so the way to cure that is to build new transmission lines or upgrade transmission lines. And because transmission lines cover a lot of property, by necessity, they have to cross private property, and therefore you get into this question about who gets to take property for a transmission line. If they want to build a transmission line, is that a public use if the power is going out of state, and questions like that. So that's the nature of the kind of eminent domain questions that are current. But they've obviously been around for a long time. I mean, we have a freeway that goes through Missoula here, and a few months ago I was doing some research and came across this case that Mr. Garlington, who's the named partner of the firm I work in, litigated back in the 70s when they were taking land for freeways and trying to figure out how much they would have to pay for that. So a lot of those cases went to the Montana Supreme Court back when they were building freeways, back when the mines were a big deal in Butte. Just transporting ore through the town of Butte, there's litigation over that. So eminent domain's been around for a long time, but what it seems to do is evolve to kind of fit with different circumstances that are going on. And then the other thing about eminent domain that has changed, or I guess made it controversial, is back in 2004, the United States Supreme Court decided a case called Kelo v. New London, and that was a case that came out of Connecticut where the issue was, could a municipality take a piece of private property that was basically going to be used for economic development, and was that a public use or not? And in a 5-4 decision, the United States Supreme Court said, even though it was being given to a developer because they were generating jobs and things like that, that was enough of a public use to survive a challenge as to whether there was even an eminent domain authority or not. Well, Kelo generated all kinds of controversy because there was this fear that all of a sudden the government had all this power to call anything it wanted a public use, take private property. And so the reaction that states had is to say what is a public use and what's not a public use. And Montana sort of dealt with that a little bit, but that's some of the legislation that's been going on right now, is what exactly is a public use that can be used for eminent domain and what isn't. And so what these panelists are going to talk about some is different perspectives on transmission lines and in some of the litigation that's been going on and the legislative response to that litigation. And some of this was triggered just a few years ago. There are a couple different companies, and I think Mark is going to, he's been involved in this litigation, so he can tell you more about it than I can. But basically, there are transmission line kinds of things, and it's both pipelines and transmission lines that are involved in this. And there was a decision that came out of the district court over in, is it Teton County or Pend Oreille County?
Well, he's both.
Okay, so anyway, there's.
And the judge.
Okay, but you know, a few years ago there was a decision basically saying that transmission line siting was not a public use. That went to the Montana Supreme Court. In the meantime, the Montana legislature passed a bill called House Bill 198 that said yes, it is a public use. So the Supreme Court remanded that back, and there's still litigation going on. There was legislation just in the last session. There probably will be legislation introduced in the next session, and there's this ongoing litigation about whether the last legislation was constitutional or not. So it's a really timely topic, and I just wanted to give you at least that background, but mostly what I want to do is introduce the speakers. So we have 3 speakers here tonight, and I'm just going to give you an introduction. What they're going to do is give you about 5 to 10 minutes overview of perspective, and as they're doing that, think of questions to ask, because what makes these things a lot more interesting and fun is if you ask questions and then they respond to them. So think of questions as they go along, and I'll try and think of some also. So our first panelist is Debbie Hanneman, and she is the executive board secretary for a group called Concerned Citizens of Montana, which she'll tell you about. She has a PhD from University of Montana here in Missoula in geology, and she also has a consulting group called Whitehall Geo Group, Inc. But she's been involved in some of these issues. The second panelist is Representative Kelly Flynn from the 68th District, which includes Broadwater County and parts of Gallatin County. Is that right? Correct. Right, okay. And those counties are right in the heart of where some of this transmission line stuff has been going on. And he has been involved in some of the legislation and also has been, since we're in between sessions, discussing some of the stuff in terms of what may be introduced in the next session. And one of the things that's going on right now is the Montana Environmental Quality Council is looking at eminent domain issues, and because they carry a lot of weight in terms of what gets introduced in the legislature, in fact, they have a meeting sometime this month where they have eminent domain issues on their agenda. And then the third panelist we have here tonight is Mark Sturmitz. Mark Sturmitz is an attorney here in Missoula with the Crowley Fleck firm, and Mark has been involved directly with some of the transmission line siting issues and some of the litigation that's gone on. So I'll let these guys each give their little background and some of their perspectives on it, and then from there we'll go ahead and ask some questions and hopefully address some of these issues. So if you want to stand up, you can stand up, or you can talk from there, whatever you're comfortable with.
So I'm going first then?
Yes.
Okay, all right. I'll just start.
You guys all hear okay?
Or do I need to?
Please use the mic.
Okay. Hello? Okay. As Steve said, I'm Debbie Hanneman, and I'm here representing Concerned Citizens Montana. Our group was formed as a nonpartisan grassroots group, and we were formed to support citizens' involvement in promoting responsible and innovative energy solutions, but those solutions we felt should be solutions that would not hurt private property rights and also basically not harm the human environment. So that set us aside from many other groups that were currently out there. And what we did is initially our membership really consisted of people from the 5 counties that were being impacted by MISTI. MISTI is the acronym for Mountain States Transmission Intertie. And those counties are located in southwestern Montana. They're Broadwater County, Jefferson County, Madison County, Beaverhead County, and Silver Bow County. Within that membership, it's really a diverse group. People come from the ranching community. We have small business owners. We have professionals that are from a variety of jobs, all the way from myself, geologist, wildlife biologist, engineers, etc. So we felt we had a fairly good expertise base to approach some of these issues. I also want to add that one unique characteristic of our group is that we span the political spectrum. I mean, we have people all the way from the conservative right to the liberal left. And believe me, it's made some really interesting dynamics for a group. But it's been good because we've been able to talk to each other and listen to each other. So that's our group. And we set out 3 main goals. Those goals are, we wanted to educate the public about MISTI impacts and the planning process and issues associated with MISTI. So that would take in what we're talking about tonight, eminent domain, as well as Montana energy policy, the national energy policy. We felt that we needed to get information out to people about those things. We also felt for goal number 2 is that we really needed to work with legal counsel on these issues. As people, citizens, run-of-the-mill citizens, what did we know about the Major Facility Siting Act or MEPA, the Montana Environmental Policy Act, or NEPA? We really needed guidance in those areas, and we needed to be able to answer questions for when other people came to us and asked us, what's going on with the planning process in the EIS? We don't understand why these issues need to be addressed. So that, and then our third goal was to contribute to the shaping of Montana energy policy. And we spent, as citizens, a lot of time in the legislative session last go-around, just trying to learn what was going on with energy-related legislation. And of course, HB 198, which, as you heard from Steve, really was spearheaded by Judge McKinnon's ruling on the Maddle line. Basically, Maddle and MISTI are merchant transmission lines. They're lines that are private ventures for profit. And Judge McKinnon ruled that Maddle, being owned by a Canadian company and also a merchant transmission line, did not have the right to take private property. So that spearheaded 198 as we were all coming into the legislative session. There were also other bills that really kind of flew very low to the ground. You didn't hear a lot about other bills that we thought were very critical, especially to transmission energy policy, was the upgrade of transmission lines. Now, any kilovolt size of transmission line can be upgraded. Before, what happened was some 69 kilovolt lines may need some assessment. Certainly anything above 230 kV size needed to go in for assessment, EIS review, and certainly what we're dealing with, 500 kilovolt in terms of the MISTI line, needed an EIS assessment. Well, now any pre-existing lines can be upgraded to, there is no maximum cap on that any longer. So that went into effect, and also in terms of an EIS process for line siting, we now have what's called the mile-wide corridor. And that means the siting assessment takes in property a mile wide. And we felt that certainly in terms of areas where the siting gets close to residential areas, that really puts a lot of property in jeopardy, of course, given now 198. And keep in mind that once the certificate of compliance is issued, that is good for 10 years, whether that line is built or not. So actually, that puts property owners under the shadow of a potential line coming in for 10 years. Anyway, so we paid a lot of attention to last session's legislation. Tried to make some impact. Well, as you can tell, obviously we didn't make a lot of impact on that. I don't know, Steve, is it good this time to go into what we think about 198, or should we wait for questions on that?
No, if you want to just cover that.
Okay. All right. As you can probably tell, Concerned Citizens Montana adamantly opposed House Bill 198. We felt that, contrary to what we heard in the session from many people, that really did significantly change Montana eminent domain law. Yeah.
Could you give us a brief overview of it?
Oh, wow. Let's see. I may pass that off to Mark, being a lawyer.
The main feature of House Bill 198 was to provide that a couple of things, that any entity that went through the Major Facility Siting Act process and obtained a certificate of compliance clearly had the power to eminent domain. The other was I think it linked any entity that was a utility, defined as a utility under state or federal law, to having that power. So those were the two key features of it. We can talk more about whether that was necessary and what the actual impact of it is.
Right, and
It was in response to Judge McKinnon's.
Correct.
right, it was from Glacier County,
By Judge
right.
McKinnon saying the bad line could be built, there wasn't a public use. Then they went to the legislature, got the law, so that was defined as a public use.
It could be
Right,
built,
and-
they couldn't condemn land.
Pardon? Could you repeat that question?
Kinnon's ruling was that Gatto did not have to delegate the authority
Correct,
to condemn
that's
the
correct.
property. It could still build the land, build the line negotiation.
Well, let me take that back, because actually there's a retroactive clause stuck on to the end of 198, and that brings it back to 2008. And that was one of the hangups with that, whether a bill could be retroactive. Swandell apparently ruled that it could. There was no problem with that. But I think, and correct me on this, I'm not a lawyer, but I think that retroactive clause actually then did give them the right of eminent domain to go back.
What happened essentially is, your question is exactly right. They can always negotiate with a landowner. And, that's fine. Really, the whole question is, do they have the authority to condemn private property for public use, and whether that's public use or not? So the original Judge McKinnon case said no, the MAD line was not a public use. So then the legislature passes House Bill 198 while the Judge McKinnon decision is on appeal to the Montana Supreme Court. So what the Montana Supreme Court had to decide in a case was whether that statute applied retroactively or not. The Supreme Court said yes, it did apply retroactively because it had all the necessary language for that. So that allowed it to go forward. Then there's actually another piece of litigation challenging the constitutionality of HB 198. That, and Mark can talk about this, but that decision just came out on that just a few weeks ago.
Right.
Wasn't the Supreme Court referred it back to the district court rather than deciding?
But the Supreme Court, as I understand the decision, said was the basis for Judge McKinnon's ruling had been fixed or corrected by House Bill 198, and then the question was whether that was retroactively. So what a Supreme Court always does is send the case back to the district court with the instructions that the essence does. Is that
And so where I'd like to pick up is exactly what Mark talked about, the entrance then of the Major Facility Siting Act into eminent domain law. The Major Facility Siting Act was really set up back in 1973 as an environmental law. Environmental provisions to protect both natural human environment during facility sightings, facility buildings. So what 198 now does is a person can come in and go through the major facility siting process, come out with a certificate of compliance, and also automatically have the right of eminent domain. We call it the one-stop shopping syndrome, because what happens, in our opinion, to landowners is that because this is going on through MIFSA, there's nothing in MIFSA really for landowners. There's nothing for landowner due process. We don't know really if our property will be targeted. If you've ever seen maps published in newspapers, they have to be published through this whole process. It's really difficult. The scale of the map is difficult to say if your property will be targeted. Now add on what I just talked about with the mile-wide corridor. Certainly for going close to residential areas, it is exceedingly difficult to know if your property will be targeted. There are no notices sent out. At least landowners in our area have never received notices about potential line routings. Also, there is no hearing. There's nothing in the MIFSA process for a hearing for landowners on the need for the line. So due process, we feel, has been thrown out the window in 198. And it also brings into play with MIFSA the idea of the toothless tiger. MIFSA has been just gutted, basically, throughout its history since it was enacted. Part of it is that there must be a public need established for the company, whoever it is, to get that certificate of compliance. The need is so broad, so general, that if this project is really being pushed, a need can be found. And in fact, if you read through MIFSA, all it says is that a need must be established. So we feel that's a really broad designation. Also, another problem we have with it, Mark, would you mind if I used your pen here?
No.
Okay, well, actually, I think I'd just like to keep this pen. Well, I think it's better than mine. So how about if I give you 10 cents for this?
Sure. It costs me anything, so.
Okay, geez, I don't actually have 10 cents. And anybody out there have a dime that I could borrow? To pay off the pen?
Taking that out of you, so.
Oh, okay. So Mark has agreed to be WAPA, the Western Area Power Authority. So what I've done is I've decided my company, Whitehall Geo Group, we really need this pen. So I can complete some reports. I'll probably, I bet after I complete my reports, hire, maybe a couple hundred people. So my need is great for this pen. Mark may have owned it, but now I do. And actually, I've borrowed some money from him to even pay for it. That's great. So we feel that, again, through 198, a private company now can take private property for their private gain. It just doesn't get any better for that. And think about the subsidy that's inherent in that process. Mark said he didn't pay anything for this, but what if he paid $1 for this? I gave him a dime, so that's a 90 cent difference. that's a tremendous subsidy that company, myself, is getting through this entire process. So not only am I taking the property, but I'm giving myself a good break on the cost of that property. And we can move on. Here you go, Mark. I'll actually be nice and give this back to you. That wouldn't happen out in the real world with condemnation. But anyways, I'd like to move on and just say, do any of you own a house that's outside of an urban area? Anybody? Oh, hey, well, I bet you wouldn't mind if I came to take your house then. Because the other thing that's happened now is we feel that Montana now has two classes of citizens. Steve talked about Kilo v. New London. All right, the Montana legislature came back in 2007 and passed legislation that in urban areas, property cannot be taken for economic development. Well, that's really good. I'm glad that happened. But what happens is the rural people do not have that kind of coverage. We don't have that safety net. So we believe then there are now two classes of landowners, citizens in Montana. I also should say that in the legislative session, we heard a lot of HB 198 will settle the problem of the one landowner that's the holdout, the obstructionist in these projects. And so it had to be rushed through so Montana could have economic development. As it turns out, of course, Governor Schweitzer did not sign HB 198 into law. He let it lapse into law, but after it lapsed into law, Mattel then condemned over 50 landowner properties. So that seemed a bit excessive to us for the one holdout. Anyways, that's a really quick rundown of some of our objections to 198. I don't know if anybody has any questions on those. And I'll stop there. I won't talk about our position on the Misty Line yet. So, okay.
I'll stand up. Can you hear me in the back? All right. My name is Kelly Flynn, and I am a rancher. And I was actually out in the calving barn today in a mud hole. And it reminded me of what happened at the legislature. Now, I was in the mud hole of eminent domain, and I was dealing with something that I hadn't seen in years. I had a cow laying on the ground that couldn't get up at all. And this cow had just walked all the way out into the pasture, and now it couldn't even get up. And I had a calf that no longer could drink from the cow. That is a lot like eminent domain. What should I do? If I do nothing, will the cow live? Well, maybe. What about the calf? If I do nothing, will the calf live? Probably not. So do I go to some experts and figure out how to fix this thing? Because how many of you grew up on farms and ranches? Raise your hand. All right. What's the matter with that cow laying on the ground? Anybody have an idea? Don't be bashful. This is a class. And your teacher told me that if you don't answer, you lower your grade. What happened to that cow?
And uttered something?
She had something matter all there. All right.
Prolapse?
Nope. She had milk fever. How many have heard of milk fever? Right back there. Your teacher knows about this. And she knows that there is a really simple fix if you know what to do. So I called somebody else, like a vet, because I am a citizen legislator. I called an expert, and do you know, in 10 minutes, that cow was up, and the calf was a little uneducated. I took about 20 minutes to fix that calf. Well, that's a lot like eminent domain. I got started into this process by a simple little bill that talked about highway right-of-ways, that taking from a highway right-of-way, and a landowner who felt like the process wasn't that good of a process. And he had some little suggestions that would probably help you if you were a property owner in the eminent domain proceeding. So we drew up this little bill. About the same time the Maddle situation came in. And the little bill, House Bill 240, turned into a major controversial point. It's different than 198. 198, a lot of us felt like if you are going to do 198, you have to balance this with some things that will give protection to private property owners. Eminent domain by itself says that a landowner should be whole in the end. In Montana law, says you have to have payment for damages to the remainder. So what we did is we took the process and created some things that would help the private property owner. Now, I'm a legislator. I am a legislator, which to me means you try to find win-win for both sides. 240, I worked on it almost every day of the legislative session in 2010. Now, we had another bill, 583, that was actually from the utilities or the entities that was also there. So what did I do? I tried to combine 240 and 583 so it would provide some of the things that the entities wanted to have and also some of the things that would help a private property owner get due process and just compensation. Due process and just compensation. What does that mean? I happen to come and represent a district where the substation was going to be. My district, Broadwater County, Gallatin County. The substation, proposed substation for Misty, was in Broadwater County. So the constituents of my district were very concerned about getting just compensation and due process. So what we did is create some things in a bill, 240, that would work toward that end. And let me preface that with something that I found from experts, because there's all kinds of experts out there, there's all kinds of lawyers, and lawyers have different opinions on both sides. I saw that. Now, I'm a layman, so I'm trying to find out what's the truth of it. What concerned me was what I heard from one of the leading condemnation attorneys in Montana. His name is Dale McGarvey. If you have studied law in Montana, you will see Dale McGarvey has handled perhaps as many eminent domain cases as anybody in Montana. He came to one of our hearings. And I'm going to read you exactly what he said because I think it's important for those of you who are trying to establish what just compensation is for a private property owner when eminent domain could occur. This is March 9th, 2010. I'm going to read this whole letter because it's very critical into what things we want to put forward in legislation. And that's what I was asked to come here and talk about is what are we going to need for legislation if we truly need a balance? Maybe the process is perfect. I don't have every answer. But I think we need an answer because here's what Dale McGarvey said. When power company lobbyists ask the Senate for a due pass on 198, they always seem to admit two important words during their statements. Time after time, they promise those whose land they would commandeer just compensation. What they mean is just a little compensation. Power companies want the power of eminent domain so that they can continue to offer 10% of just compensation. And if the landowner balks, they remind him that now the burden of proof complete with extremely high fees for lawyers, appraisers, and engineers, lies on his shoulders. And after a couple of wallet-draining months of legal wrangling and ulcers, he's likely to accept just a little compensation to make the ordeal stop. A polite word for this ploy would be intimidation. Landowners are often appalled to find that the state of Montana, flexing its eminent domain muscles, regularly offers 31% of just, true compensation. But that's almost generous when compared to a typical power company offer of 10%. That's disconcerting to myself. It's disconcerting to both sides of the aisle. I can tell you, and I see Representative Hands in the room, this issue was an issue that cut across party lines. It wasn't just the Republican. It wasn't just the Democrats. It was people off both sides that were concerned about this, that unless you have money, unless you have will, unless you have the willingness to fight, you will never get just compensation. And part of the reason, and one of the things that I will try to come out with a bill in the next legislative session, is over litigation costs. Because for a property owner to get true just compensation, they are going to have to spend a lot of money up front because the burden of proof is on the property owner. So those litigation costs have to be paid up front. Not your attorney costs. A lot of those are on a contingency basis. Litigation costs can run extremely high. The Maddle case right now, over $100,000. The case with the farmer who got me into the mud hole, over $100,000 in litigation costs that he has to pay out of his pocket up ahead. One of the bills I'm considering is to require that the entity who is condemning pay interest costs on those litigation costs from the moment that they have condemned the land until the case is settled. That only makes it even for the private property owner. I did some other things that I wanted to try to do for private property owners. What happens is in eminent domain, or in the proceedings up to eminent domain, the entity can continue to put a chip on the pile all the way. And if you lose as a private property owner, if you lose, you have to pay all your litigation costs. And that's troublesome when you're a private property owner because what they're offering to pay you for that land might be a small amount of money, but your litigation costs are huge. And those property owners are risking losing their place because somebody has decided to take their land. One of the provisions I had in House Bill 240 moved the final written offer up prior to the filing of eminent domain, 30 days prior. And what the commissioners would decide on and the court would decide on would be based on that final written offer. It doesn't make the final written offer just the last one all the way up the courthouse steps. It makes it with a fixed date. That makes the entity put a good faith offer out there. Other things that of course, we tried to do in the legislature was a lot of folks wanted to have some kind of incentive payments. I want to have a hats off to Maddle. Maddle had a per pole payment, may not have gone far enough, but an ongoing per pole payment. We tried 3 different bills in the legislature to try to do that because sometimes for private property owners, that's what it takes. If this is truly a public use and public necessity, and the value of the land is devalued, because, of course, in Montana law, you are supposed to pay for damage to the remainder. And as I have studied this, there is a huge spectrum of studies that talk about what happens, is that extra outside of the corridor, the right-of-way? Is it devalued? And I've looked at a lot of studies. Quite frankly, some of them say there's no damage. Some of those are paid for by the utilities. What I found recently is by actually an appraiser out of Wisconsin, valuation guidelines for properties with electric transmission lines. And let me be clear about electric transmission lines. What we are talking about is 230 kV and up. We are not talking about distribution lines. We are not talking about eliminating eminent domain. That is a part of Montana law and a necessity to be a part of Montana law. What we're talking about are merchant transmission lines, essentially running power straight through the state, could also be a pipeline. This particular man says in recent studies, this is Kurt Kalish, he indicated there was a measurable effect, and the effect ranged from a loss of 10 to over 30% of overall property value. That's huge. That's huge. And that is a bone of contention between the entities and the private property owners. And the burden right now falls on the private property owner to come up with enough money to prove his case. So, I've thought out loud of things to do. I don't have all the answers. But I will tell you, if this is truly a public necessity, and that's arguable, I have looked at the Montana law. It does not clearly define what public necessity is. It's in Montana law. Does that mean it's for Montanans? Does it mean it's for beyond Montana, the United States? Does it mean it's beyond the rest of the world? It is not clear. What does it mean about benefit to the public? Is that 2 people, 5 people? Let's just say that it is definitely a public necessity. Now, I come off the Republican side of the aisle, which means we never have new taxes. So what I have looked at is there a way that we could look at a property tax credit, an ongoing property tax credit that would go to landowners? And here's how that's done. On these transmission corridors, there's what's called a centrally assessed value. And that's determined by some folks on exactly what they say that the amount is. So let's just say it's $10,000 a mile. That is going to come into the counties. The counties are going to get a windfall from this. They're going to get a windfall, but if there wasn't a transmission line, they wouldn't get anything from that. 100% of nothing is nothing. But what happens if we took a portion of that on an ongoing basis of that centrally assessed value that is going to be paid no matter what? It's not a new tax. And that we distribute that to property owners. Will a property owner have a better opinion about having his land go to a transmission line? I don't know, but I'm thinking out loud on that one. Now, what I tried to do in 240 is another thing. If you look in Montana law, 7031-301, Federal Relocation Act, all processes that involve federal dollars have to go through that right now. What I tried to do was move that over so that everybody had to do that. And within that, I believe it's number 7 in there, talks about coercive in nature. Eminent domain, by its nature, is coercive in nature. But you would have thought that I'd have poked a wild rhinoceros with that one when we tried to move that over so everybody would have to do that same thing. That was one of the big holdups. Something that even our state DOT director said, we don't have a problem following that. What we also tried to do for the entities is get the timeline shortened down, because the timeline can be pretty long. What we tried to do is benefit the utilities by changing those timelines and also working with the amount of money they have to deposit. Now, as you can tell, 10 minutes or 15 or whatever this is, I could talk for an awful long time about legislature and what happened in legislature. I want to tell you something that happened the last day, and I shared it with him. 198, it originated in the House. A bill, if it's not passed on to the governor, because Governor Schweitzer was going to put a pocket veto on that bill, because he wanted to give us time to sort out what was going to happen on Misty. So on the last day of the legislature, I did something that legislators who are freshmen don't know about until they move along in the process. The bill goes back to the House it originated in. Your right as a legislator is to move to suspend the rule, and if 2/3 of the body votes for it, that moves the bill back out for another vote on the floor, which is what I tried to do. I caught a lot of people unawares, and I don't think some of them even knew what I did. People were voting on all sides of it. It died by 2 votes. We were going to bring it back up again, because if it would have come to a 50-50 vote on that last day, I think it would have failed. Because at the start of the session, guys like me who are beginners, we were told that 198 would be linked with something like 240 that would provide eminent domain along with a process that would be better for just compensation and due process. Well, we separated them. That wasn't part of the deal. And that's one of the things that had propelled me on through 3 months of trying to find something that works for everybody. Because at the end of the day, I am a legislator and I am not a capitulator. So with that, I may have sparked a few questions. I'll sit down.
Well, I was going to say thanks for inviting me. Changed my mind. But I do need to say that while I represent clients that have been involved and are involved in eminent domain in some of these cases, I'm not here representing any of them. I'm here representing me. And so nothing I have to say is anything but my own personal opinion. And consequently, if I was standing up in the courtroom and arguing in rebuttal to the points that have been made, I might approach it a little bit differently than I'm going to this evening. I don't know, what the range of understanding is here in the room about eminent domain or the law of eminent domain. I learned this the hard way. My very first eminent domain case is the Maddle case. And boy, what an education I have received. And before that, because I knew literally nothing about condemnation in Montana, all I knew was Dale McGarvey, because I practiced law in the Flathead for about 9-10 years. And Mr. McGarvey made a very tidy living representing landowners, which is the irony of his statement. Because why? He was a past master at getting $1 more out of the court than the company would offer his clients, and all of his litigation costs and fees would be paid. So this illustrates one fundamental point I want to make here. And if I make no other point that registers it, is this. There is so much information out there in the ethers about eminent domain now in Montana, so much debate, so much dispute, that it's become like my day job as an attorney, which is environmental law, which I've been doing for the last 30 years, where most of the debate is being carried out in the extremes. And that has been the single most frustrating thing for me, having gone through the Maddle experience, because there we're in a court of law. And I should think that if nowhere else, in this state, there we ought to be able to agree on what, at least what clear and unambiguous statutory provisions say, and leave the ones that are subject to dispute or interpretation to be disputed. But that is not what is happening here in Montana. The statement, for example, that there's no hearing available in the Major Facility Siting Act, false. It's a false statement. And what I'm going to urge you to do, because we'll never have the time here this evening to either convince, change anybody's mind, change our own minds, educate you sufficiently if you don't already know about eminent domain, to leave you with anything other than probably some of the frustration that I feel, is to point you in the direction of the statutes and the cases. You have in the back of the room a brief that Ms. Lund has filed in the Mauer case, it's called now, which is, this is sort of Maddle number 2, second generation Maddle, following HB 198 and Judge McKinnon's decision. And what has happened there procedurally, so you know, is that Judge Swandle now out of Livingston has a bunch of these cases, and they've designated a lead case, the Mauer case, to hear the legal arguments, which will apply to all the other cases that are following along. That brief, I can assure you, if you read the other side of the story, will read a lot differently than read in a vacuum. Judge Swandle has ruled now already that House Bill 198 is constitutional solely on the due process issues, the issues of notice, the issues of publication, of hearing, of opportunities to be heard, of the amount of knowledge that landowners have when a project like this originates. And he has, and I'll be glad to provide a copy, but he has ruled that the Major Facility Siting Act and the changes to it do nothing negatively in regard to due process, nothing, and that actually the Major Facility Siting Act, as it always has, is an additional layer of due process over and above the eminent domain proceedings. Keep in mind here, like for Maddle or any of these projects, the action is not all in eminent domain, and as a landowner, I could appreciate a lot of sensitivity about that statement, but Maddle, for example, went through a NEPA process because they had to get a presidential permit because the line crosses the international border. They had to go through FERC processes. They had to go through not only the Major Facility Siting Act, but MEPA. No one here has mentioned MEPA. That's a whole other layer of regulatory process that's involved in these situations. All of these things occur before you ever get to the eminent domain stage, and then you have, in the eminent domain statutes, the due process that's built in. Now, anybody's free to debate whether, especially, if you're a landowner and it's your property that's being taken, I can completely understand, wanting more rather than less process, or certainly wanting some if you don't think you're getting any. But those processes have been upheld in courts in the state of Montana, and I'm speaking now of eminent domain, for many, many, many years. And let's talk specifically about one particular sore spot, which is this statement about merchant lines. Maddle is a merchant line, and the reason that term has come into play is because it basically means you're providing transmission. It's like a highway for electrical energy. You're not generating it. It's a FERC definition, and it provides FERC jurisdiction. And but it's being used pejoratively, of course, to convey the thought that, well, Maddle shouldn't have the right to condemn because it's making money on this deal. It's helping its investors. And, okay, if that's the policy of the state of Montana, that no one should be able to resort to eminent domain if the profits that come as a result of the project benefit the owners of the project, fine, let's say that. Well, where has that been? Does anybody think the railroads in Montana did not make money? How about the power company that's been condemning property since 18 whatever? The fact is, the case law, if you get into it, absolutely does not hinge on whether there's a private benefit. In fact, it does not even hinge on whether it's mostly a private benefit. Now, you know, whether you agree with that or not is totally your right. That is the law. And if there's anything else I can convey here, it's, you know, let's be honest about this debate. Again, let's debate what's debatable and not what's not. Judge Swandle's opinion, and again, I think it's probably the best source right now given where we are in this process, which is clearly not going to end until these cases probably go back to the Montana Supreme Court, or until maybe the legislature comes in session again and wants to change the law, which is completely their province. That's where this came from to begin with, by the way, the legislature's grant of authority. Judge Swandle's opinion is really the state of the law in Montana until somebody proves it otherwise regarding due process and eminent domain. Now, it doesn't go to some of the other key issues that we're probably going to talk about tonight and that still, you know, that were contested in the Mattel case. You have public use. Is it a public use under the statute? You have the necessity, and you have the location. And then finally, you have compensation. Those all remain to be litigated because we got hung up on use in Judge McKinnon's court. I will say before I sit down, because I want to keep my remarks brief for questions, that it is also, let's put it this way, it sells the Department of Environmental Quality, the Department of Energy, the regional power transmission authorities very short to say that there has not been an adequate determination about public use or that there's no way to tell the scope of that. It's also, I think, really unfair to describe the Major Facility Siting Act as an environmental statute. If you think it's just an environmental statute, I'm sure Mattel would have loved to have saved a few bucks in going through the Major Facility Siting Act and not have had to submit all of the information about the cost of the project, the benefit to the state of Montana, the economics, the socioeconomics, the cultural resources, the volumes and volumes of material that go into 3 years of process at DEQ before they could get a Major Facility Siting Act certificate. That has nothing to do with the environment. So it's what it is. It's an omnibus. Many states have it. An omnibus kind of one-stop for lineal projects that are big enough in scope to trigger jurisdiction. The last thing I wanted to say is that as to the issues of necessity, of location, and whether there is actually a need and defining the scope of that need, Representative Flynn's statement is really, it's a good one, because even if I didn't agree that the statute was clear enough about, you know, what the regulators are to consider, I will say this. I mean, Montana is feeling the effects of what goes on in other places. And now, you know, we're going to be feeling the effects of what we have here in terms of our own resources. You know, these power transmission lines, for example, I mean, Mattel is maybe not a good example because it's specifically designed to take what was captive wind energy being generated in Montana and get it out onto the market. Do we want wind energy in Montana? These are going to be my rhetorical questions. Do we want to build wind energy, wind farms that don't have the ability to get out of state to be sold? Do we want to have more fossil fuel development? Do we want to have no energy development? These are all questions for energy policy, not for what we're talking about here. But the fact is that, you know, in the western part of Montana, our power transmission is integrally linked with the Bonneville Power Authority. In the eastern part of the state, you got Montana Dakota Utilities. Like it or not, we can't just sit here in the state of Montana and pretend like we're not part of what's going on nationally or globally. That is, to me, that would be dangerous thinking. We've got to deal with it. Maybe this is where the rubber meets the road, and I think one of the points the landowners make that I fully appreciate is they're the ones that are paying part of the price here. All things being equal, who would want a power line going across their property? No one, probably. But eminent domain, fundamentally, has got to be one of the more utilitarian concepts in the law. And, then that's a debate for another time, perhaps, but as harsh as it may sound, or as harsh as it may be, there's a policy decision there that as long as you can prove that this benefits the public and the legislature has delegated the authority to, in the case of a private entity, or it's a governmental entity that's pushing it, like a highway or whatever, then the implicit in that is a statement that this is good for the order. It's good for all. And yet it may not be for an individual. And so eminent domain is it's probably the most direct statement of a utilitarian thought that we have in our system of laws, I've come to believe. I will say, too, one last comment, that this is just an experience that we see from representing companies out there, and I don't mean this as an argument against the landowners who wish to dispute anything. But the truth is that the vast majority of landowners sign willingly and settle up, and you are fine. They get what they think is fair. There's a lot that do not feel that way, obviously enough to keep this debate going and to continue it. But the truth is that one of the things in eminent domain, one of the fundamental thoughts is, do you want to have a landowner, for example, one, holding up a line that, or whatever it might be, that the public has decided it's to their benefit? Do you want that? Or how much leverage do you want to give them? I don't know, but that's really the hard questions, one of the hard questions that we have to face.
So I think maybe the best thing to do is see if anybody has questions out there. Or you have, okay, we'll make it go that way.
I would love you to elaborate a little bit on the hearing that is part of the process.
Can you restate the question?
Yeah. I asked Mark if he would elaborate a bit more on the hearing that is a part of the MIFSA process on Montana Facility Siting Act, or Major Facility Siting.
I was going to try to find Judge Swandle talks about that as well. This is a quote from Judge Swandle's opinion on the constitutionality of 198. The MIFSA process provided landowners with an additional opportunity to participate in the administrative approval process. It cannot reasonably be contended that it somehow reduced the amount of public input on siting Battles Line. One of the purposes of MIFSA is, quote, this is from statute, to provide citizens with the opportunity to participate in facility siting decisions. I'm moving on to the specific due process. And I'll paraphrase part of it. MIFSA, if you don't know, involves stages linked integrally with the MIPA process, where an EIS is being prepared to provide drafts for review and comment. The ultimate hearing is if you don't like what the decision is, you have the right to appeal and to a hearing. If you don't like that, whatever happens there, you have the right to further hearing. And that's on top of just, the ability to comment as the process unfolds. From a practical standpoint, too, and I'm just going to say this because I know what's happening in Maryland. DEQ is sensitive, extremely sensitive to the opinions of individual landowners, I believe. And the reason I believe that is because I have seen them reroute lines or suggest strongly to the utility that it reroute a line in order to keep one person happy, or to keep it from being mad, maybe I should put it that way. And the problem is, this is a lineal facility, so for every action, there's a reaction somewhere down the line. And that's literally what's gone on in Matto, where you have kind of piecemeal changes that have occurred. But if I were representing landowners, and I do, by the way, represent landowners too, the thing that I would say to you is pay attention to every piece of paper that not only comes to your doorstep, but the legal notices and any other source that looks like it may touch on your property. When it gets to the specific point where a company is wanting to run a line through your property, you have to know. I mean, if you don't know, there is a problem with due process. But what I've seen happen in Matto and other cases as well is people getting things in the mail and not paying attention to it, or feeling like, well, this looks like it may affect me, maybe it doesn't. You can't afford to do that because every event, every public hearing, in the Major Facility Siting Act, they had hearings in public meetings in Great Falls, Cut Bank. I mean, one of the things that was disputed was whether people got notice, and we produced the sign-in sheets with people's names on them. Some of the people who claimed they didn't get any notice signed a sheet in the door where they attended the meeting. It's that kind of thing that bugs me. But be that as it may, I mean, everything has a legal reason in the process. It's key.
So I would just say to that commenting and personally talking to people is much, much different than an actual hearing on the need and necessity for the line. So what I see in this is that there is no part in there that is really for landowners. It's not until after the company has the certificate of compliance, and then automatically the right of eminent domain that one can proceed to those points.
Okay, I see your point. I disagree for this reason. While NIFSA does, and as I said, it's not merely an environmental statute. It does address purpose and need. The NEPA process addressed purpose and need. And, there's plenty of law out there on NEPA and how much process is due people. But the NIFSA process, in my view, when we litigated in front of Judge McKinnon, that doesn't foreclose a challenge completely to purpose and need in the district court. Now, one of the things that's being fought, as you may know, in the cases that follow Matto or Matto's successors, is a Montana Supreme Court opinion that basically says if you have a NIFSA certificate and then you're later in a condemnation proceeding, that the NIFSA certificate is what's the word I'm looking for? It's not prima facie, but essentially that's it, showing a purpose and need. And the reason for that is because I don't think the courts want to get into a situation where a judge in 1 day, 2 days of hearings, 1 month of hearings, 1 year of hearings wants to replace what DEQ did over 3 years. So challenges have been made legally to whether NIFSA itself is constitutional, and they've been turned down. So I guess my point is, if you've got this siting act that's constitutional, and you've got eminent domain that provides an additional process that's also constitutional, how do you put the two of them together and come up with unconstitutional? And I think that's the problem that Judge Swambo had. That, NIFSA in and of itself, that certificate, doesn't affect your property. 1 iota, nothing. It's the eminent domain process is where it happens. So that's the key part of this finding.
Right, it's almost a circular.
Well, in fact, I don't think so. Yeah, right.
Okay.
with all due respect, we were at a public hearing where the director of Montana DEQ stood up in court and said, public need is inconsequential, we're paying no attention because we can always find what do you do?
I don't know, I don't agree with that statement. That's all I
Well,
can say.
and he's the one who signed.
I mean, that contradicts the stack of paperwork that came out of his department, so I don't know. I don't know what to say to that. You know.
Well, I did. I was dumbfounded when he actually said that.
I mean, by the way, the regulations, not the statutes, but if you look at the NIFSA regulations, there's guidance in there about public necessity and then what they have to find. I mean, DEQ is charged with finding that by law, and there are boxes they have to check. So I don't know what you can.
And one other comment, and maybe Representative Hammond, since she was there, had, I believe, had a hearing for EQC when they were considering eminent domain, called in a couple of representatives. And towards the end of that discussion, one of them said, you have opened the possibility for a landowner with a wind farm coveting his neighbor's land and being able to say that is public need, I would like that land. That also came under 198. That was really kind of started.
I would say, you know, I might take that a step further. There are plenty of cases, if you look in the Montana statutes, of private landowners fighting with each other over eminent domain, particularly for roads. Okay, I mean, the government has nothing to do with it. There was a recent one that came out, I can decided, give me a chance, but within the last couple of years, where one landowner was using eminent domain to declare a right-of-way over them. I had a case one time where I declared a right-of-way on behalf of private citizens over land owned by a private company for mining. I mean, the statute is clear, it's mining. It's one of the things. So, I mean, one of the issues that's come up in that was this question about whether or not, it's in, you know, this will sound familiar, whether it's just to the private benefit of Mattel, whether that, because it's a merchant line, you know, can anybody else benefit from that? And I mean, the law says, and the findings of FERC and state say, in fact, FERC's tariff for Mattel requires them to make it available to anybody who can qualify. Well, the truth is that most people don't want to go to the expense of building their own power line to serve their property. They're going to get it from Northwestern Energy or whatever. So the reality is there's probably not anybody who's going to want to do that. But in arguments in court, there's one said, well, then I could get on the Mattel. I could use my property. I could condemn somebody else, and you know, we could have a fight between landowners about who gets to build the wind farm or who gets access to the transmission line. And my response was yes. If you can show a public use, you can avail yourself of the statute just like anybody else. To me, that's kind of a false, but yet, you know, somewhat horrifying scenario that doesn't advance the debate very far.
But in my mind, the analogy is that here you have one money-making kind of Mattel and another a wheat farmer or barley farmer or whatever. And the law says one industrial use takes precedent over the other. That doesn't seem quite right.
Well, yeah, I'm not sure exactly what you mean, but the cases do talk about, and it's in the filings that everybody made, the extent to which the extent of the public benefit that must be necessary to make it a public use. You know, of course, one of the arguments that we made, that Judge McKinnon didn't like, was that if the statute says it's a public use, it's a public use. If the legislature has declared it to be a public use, it's a public use. And the legislature has declared an electric transmission line to be a public use. I'm not making that up, that's what the statute says. And what the landowners convinced Judge McKinnon of was that, no, there's another requirement out there. This was the fundamental problem in that case. There's a whole other requirement. You won't find it in the statutes, by the way, but it is that you've got to have another statute that gives you, whatever you're doing, the specific right of eminent domain, beyond the fact that 70-30-101 lists transmission lines. And so you have that for common carrier pipelines, you have that for, you know, various other kinds of entities, electric co-ops perhaps. I mean, there's a whole list. And so that's where she balked at what was going on.
But then the question also becomes regulated utility versus deregulated utility.
I don't think that's relevant at all, in my opinion.
So, yeah, tell me a bit about that.
Well, I mean, first of all, Mattel is a utility. They're a utility as defined by both state and federal law, okay? And I can cite to why they meet that definition. So why we're arguing about, in the Mattel case, about whether, you know, the effect of being a utility is beyond me. This idea that if you're a utility, you've got something greater than what non-utility has was created by, and very effectively, by the landowners in the Mattel case. Up to that point, and you can debate this if you look at the legal briefs, depending on, you know, whose cases you believe. No, there was no decision in the state of Montana that hinged the ability of eminent domain purely on whether or not they're a utility. You know, it came out as an adjunct, I think, of what I was saying before a minute ago, which is that it isn't good enough, according to the landowners in that case, to just be have a public use. You've got to be a regulated utility, or you've got to be whatever, you know, you name it. And so that's where that stems from. I think it's unnecessary. It featured though in bid, I think, in the legislature in the debate about 198 and the other bills, because you know, there were companies, for example, that took a look at what was happening in the legislature and decided, you know, we don't need to be involved in that because we got our own statute already, or something to that effect, you know. And so from a political standpoint, I think it's very relevant to how the powers line up in the legislature. From a legal standpoint, and again, Judge Swandle, I mean, it's in the briefs, but there are definitions that make now the utility.
Right, I think gets used because they were regulated by FERC.
Well, they're also utility under state law. They're utility under the Federal Power Act. Any person who owns or operates a facility subject to the jurisdiction of FERC. And by the way, if Montana Power, I call Montana Power, but Northwestern Energy, was doing this project, they'd be under FERC jurisdiction too, for the very same reason. It's interstate. And it wouldn't matter what their state, you know, what's the word, label was. If you give me a second, I'll find the state definition. But again, to me, it's an argument that doesn't really make a difference one way or another.
Yeah.
Can you tell us a little bit about the AB 125, the petition, and what's happening with that?
Oh, okay, the referendum.
You can use your.
I can
Yeah.
use this. With that, it ended up that I think somewhere over 9,000 signatures, certified signatures, were collected. There was a total, I can't remember now, I think around 24,000, 25,000 signatures that were needed. And Concerned Citizens Montana did file the language for that. It was later taken over by a political committee. It was called, I believe, Real Montanans for Fair Land Use. You know, as we look back on that, everyone that was involved, we did not have a statewide network that functioned well. We also didn't have much money. I think now, being a little wiser about that is you really do need to have paid signature gatherers. As I said before, you know, 198 really hit rural people. And that's the time of year, you have 90 days. And we had to wait for that language to be certified through the state. And I think that brought us down to, it was much less than 90 days. Many of our workers, they're out working. We all have day jobs. And it was tough. And so we felt good, actually, collecting 9,000 certified signatures. Yeah, hindsight is great. I know we do it a lot differently, but probably lack of a statewide network, bad time of the year, and you really do need paid signature gatherers. So it's done. We had to have, whatever it was, 24,000 signatures by September 30th, and we didn't make it.
Any other questions?
I found the statute, but I don't have the language right in front of me. I know I have it in my nest here somewhere. It's 69-3-101 MCA is the utility definition for the state.
I guess I have a question for Representative Flynn. There's a lot of debate right now, not only about the electric lines, but Keystone XL is one of the other big debates out there. And Keystone XL is a pretty popular project with a lot of people in Montana. I guess what I'm wondering is, as you go through this legislative process, how much do you have to be careful that you are both protecting landowners, but also if you are in favor of the Keystone XL project, which will be a big jobs project for Montana, that you don't somehow impede the development of that at the same time?
I'm for the Keystone project.
Yeah,
I think, as I have studied this, there are some definite differences between a pipeline and a power line. And we need to recognize that and gather it up. Pipelines don't necessarily cause a devaluation to the remainder like a power line that is larger than 230 kV. And I think we need to recognize that. The jobs issue. The jobs issue in my area, in my district, where Misty would be. I went to the two folks from Northwest Energy to talk about jobs. And the one fella, who's one of the leading guys for Northwest, said to me, it will bring you one permanent job for your district. One. The other guy, when I talked to him, he said, it will bring you zero jobs. And I'm supposed to look in the eyes of my constituents and say, we're bringing jobs to you. That's why when we talk about this debate, you didn't hear me talk about whether eminent domain is a necessary process. You heard me talk about, and you will hear me talk about on the pipeline, the same thing. How do we get just compensation for those pipeline people? Because that, at the end of the day, for a lot of those private landowners, that's what they want. They want to be treated fairly through due process. We can argue whether it's the best due process or if there could be better. But at the end of the day, for projects to go forward that are of this scope, that are merchant-type projects, the more incentives you have for those private property owners so they feel like they have just compensation, that they don't have this immensity of costs, like would happen on the pipeline, which happens on the power line, which happens on any of these. That's what we need to be working on, in my view.
I guess just to follow up on that question, I think it's a really relevant and interesting question. I mean, if you look at the Keystone Pipeline and you talk to the landowners in eastern Montana,
they would argue that the environmental risks are what they're concerned about over maybe their property value risks, but it does devalue perhaps their property value due to the risks of environmental contamination. And we saw that just this last year with the Yellowstone pipeline, the oil spill. And I guess the one other thing I would like to say about the jobs argument is that, I mean, the pipeline is, you could say it's transitory jobs, but for people in the Bakken Formation, they would argue, well, you know, this is an on-ramp for our oil and gas. Well, that's what people are arguing on the transmission, is it's an on-ramp for wind development. So when you're looking at jobs as a statewide piece, and as a state legislator, you have to think about it in that holistic realm. You know, what's going to bring in taxes for our state so we can operate the things that we need, like roads and other types of infrastructure and local government needs. So I think it's very relevant to compare the pipeline and its risks with transmission and its risks, and the jobs evaluation is equivalent. I mean, you have jobs in Bakken, you have jobs with wind development. So how do you evaluate that, I guess?
I'll take a shot at that. And actually, let me go back to one of the things that I'm throwing out to people in regards to if this is a public necessity and the public stands to gain predominantly by taxes, maybe not even so much by job, but maybe it could be job. Should we be taking a look at giving those landowners on the pipeline a percentage of those property taxes that are generated, percentage of those property taxes generated, the same way as we are doing for the wind folks? Now, some people argue, should it be 4%, 5%, 10%? The bottom line is I think it should be something, because that helps folks who are going out and talking to private landowners. It gives them something. You're not going to have every single private property owner sign. That's a fact. We know that, and that's why we have to have eminent domain. But it gives them something more down the line. And so that's why I'm looking for ideas to take to the legislature that will bring something that they can look and say, yeah, I think we're closer to just compensation. Speeds up the process for the entities, lowers the costs, and I think at the end of the day will better serve the entities and better serve the landowners.
Can I jump in on that? One thing I'd like to say is, in this discussion about transmission lines, pipelines, it really depends on how those things are actually built. And I'm going to talk specifically about transmission lines and how those things are done. Overhead, buried, there's a huge difference between an overhead AC line versus a buried DC line. And I'd like to just say that probably the second week of April, John Vincent, who is PSC Commissioner District 3, I believe, will be holding several news conferences, starting in Helena and a couple other places around his district, on how we might do transmission lines that I think would appeal to landowners, the wind people, etc. So there are other ways to do things that we need to look at.
Just one more question about, we were talking earlier about the outer, looking at some other states and what they do with eminent domain. And I just wondered about Nebraska was able to successfully stop the Keystone Pipeline from going through there because of the aquifer, and they were very concerned about their aquifer. So I was wondering, do you know what they were able to do with eminent domain on their state, not have that, the Keystone Pipeline go through?
I know a little bit about it, but I don't think it was eminent domain law. It was whatever their equivalent of private major facility siting that was, and that's all I'm going to be able to say.
Wasn't it Obama's presidential permit like you got for Wales?
Well, tangentially, he has to issue that permit, that's a fact. But I think from a political standpoint, they were looking at what was going on in Nebraska. Don't take this as gospel, it's my impression, as kind of directing what the White House might or might not do with the residential permit. They got kind of linked in a political sense, but I don't think they, there's no legal, strictly speaking, legal linkage. An interesting thing, and people are going to think I'm a creep for this one, but look online at that whole, I had this impression, they're talking about, what is it in Nebraska, what's that feature called?
Sand hills.
The sand hills, yeah, we've all heard about it, it sounds like something we ought to be protecting. Look at the existing transmission and pipelines that are already there. It's like spaghetti on a page. It's amazing. It really does make you kind of wonder, but I'll just offer that, it's out there. It's stunning to me to see. I didn't know that was the case.
I just wanted to respond to Representative Flynn's revenue sharing proposition, which I think is an exciting one. I think it runs into some real problems in existing Montana statute. And for those of you who are law students who are interested in the banal world of fiscal policy, I encourage you to look further at that. I think it's a very important way in which communities experience the impacts and the benefits of energy development, both with fossil fuel development as well as projects like transmission and renewable energy. In this state, we have kind of declared ourselves open for business by creating a whole series of holidays and tax incentives, both for fossil fuel producers but also for renewable energy producers. That creates a real problem for local governments with projects like Battle and Misty, when if they qualify as carrying a certain amount of energy for qualifying facilities that are deemed as renewable, then there's a major tax break to them. So the local governments may or may not get significant revenue. So when you begin to talk about what of that can we share with property owners, one thing that we could do in this state is just revamp our utility taxation code, which is dates to being basically a company zone where utilities are taxed at a very high rate in some cases and very low cases in others. I think that's a problem facing our state.
I'll take a shot at that one, because I took a shot at that one at the legislature in regard to that kind of taxation. What I tried to do was have companies come to voluntary property agreements. Voluntary property agreements. And if they did, they got a lower rate than what was out there. I had it proposed in a bill. Rather than paying class 14 rates, that they would go by a different rate. You're right. On the renewable energy side, we have passed a law that takes them from 12% down to 3%, and for the first 19 years, they can go down to 1.5%. I used the exact language that the entities said. They said, we hardly ever condemn anything. Less than 3%, 2% of the times we have to condemn. So I said, all right, let's make it so if you can get 97%, then you get the lowest rate possible for that stretch of line. But if you don't, you will have to pay that highest rate of 12% plus. I provided that for the other entities, because what we do, we tax hydro, coal, natural gas, we charge them 12%. But when we go to renewable energy, we go at 3% or less. So what I tried to do is create an incentive, and if you look at the amount of money generated, centrally assessed value, it's a huge number. It's a huge number. And if an entity, yes, they'll probably have to pay the private property owner something. I didn't want to put in there what they had to pay, just that they had to come up with a voluntary agreement, trying to give them an incentive to do that, because the difference in rates, it's huge. And of course, you've already mentioned there's this other power on the renewable lines. The best of the renewable lines gets about 35% efficiency. 65% of the base load essentially has to come through coal, natural gas, or large hydro, or nuclear if we decide to go nuclear. But anyway, That's what I tried to do. I recognize there's going to be less value to those counties. It's still a huge amount of money. I don't have it in front of me. It's a giant pot of money.
I have one more question, but does anybody else have a question? I don't want to steal. Okay, my question, I think it's for Debbie, is when you start talking about public use, one of the reasons why at least Misty, I think, is being built is to get power out of state and to make Montana more of a generator. And part of the reason for that is states have decided to step in where the federal government hasn't and adopt what are called renewable portfolio standards, where a certain amount of energy has to be generated by renewables. So like California, I think it's 25% or something like that. And they want to build wind farms in Montana so they can meet their utility standards. Well, if you start labeling them as merchant lines, when really, at what point does that factor into whether it's a public use or not? The fact that it is going to help states meet their renewable portfolio standards, which is in response to global climate change. Does that cut it all against the argument that it is not a public use? Or how does that weigh in with the landowner concerns, which are very site-specific, versus the more global concerns about responding to the environmental yes?
Right, so that comes down to the question of what is this green line?
Okay, and maybe that's a good way to close, is just if you could talk a little bit about what a green line is.
Well, Megan sent me that question, and actually I really appreciated that. That's really a good one to think about. If you've looked into that, there are no standards for what qualifies as a green line. The FTC may come out with some standards that's way off in the future as far as I can tell. But I think the way people have looked at green lines, because, geez, the definitions are all over the page. If it transmits 1 electron of green energy, it's a green line. Other people say it's got to be wholly renewable generation that goes on that line. But, you know, you can look at a line in two different ways. I think the best way to look at lines are in terms of generation and then also in terms of the line itself. When we talk about Misty, the way Misty is set up right now is that it starts at Townsend, and depending on the route, maybe 430 miles to midpoint Idaho. It is tied into the Colstrip east-west line. When the substation, about 52 and 80-acre substation, is built. So immediately it's tied into coal energy primarily. There may be some natural gas generation on that. But right now, Northwestern has had 3 open seasons starting in 2008, I believe, and they have no takers. They've had originally some transmission service requests. Now, these are not firm commitments from companies. They came primarily from PPL Montana, a company called PowerX, which turns out is an energy trader, wholly owned by BC Hydro. They'd be looking at hydrocarbon, coal generation, and also Idaho Power, IPCO, I think if you read the draft EIS. So if you look at this right now, generation is not renewable. That's not to say in the future that there may not be some, but right now it stands as coal, probably a bit of natural gas. So you look at that generation, and it's not renewable generation that's going to come down there in the near future. But also, I think people should look at the line itself. You know, what is a truly green line? It should be a line where there isn't much line loss. And overhead AC line loss, depending on the physics of the line, can lose up to 30% of the load. I think a more typical percentage is 10%, but still, when you compare that to other technology that's out there at the present time, you know, DC, it's a 1% line loss. Like there's a huge difference. If we're really talking about green, energy efficient energy future. So that's part of our problem with this, looking at that. yeah, it's an argument. I guess you can say, build it, they will come. But right now, to pass it off as a green one, yeah, we have some argument with that. As I said, there are better ways to do it. You know, CCM really does stand behind renewables, but we want them clean and we want high efficiency with them. We're also a bit worried about Misty because we look at that as more industrial scale infrastructure. We would really like to see distributed renewable energy. So we look at that and think, yeah, that's one more lock into the future of industrial scale renewables. And that can be debated too. But anyways, those are our hangups with that.
Could I comment on that just real quick? I'm not going to talk about the green. I don't know anything about that, to be quite honest. But I think this whole discussion illustrates how important it is to have a comprehensive energy policy that really gets vetted and debated by all the interests, which we don't have. And I think it's been, as an environmental litigator, real interesting to see the environmental group stand on the sidelines while wind power has gotten as far as it has. Because, you know, what's happened then is when Matto had their open season, they were signed up just like that. I think part of that was nobody thought it would end up, you know, being the litigation piece that it has become. But for Misty, this is a rhetorical question, who's going to sign up for a line that's started in litigation is obviously going to be in litigation. So I think, you know, to say, well, they don't have any subscribers when you're fighting vigorously to make sure they never have any is something to consider. You know, DEQ has the authority under the NIFSA certificate to issue it to them if within a certain, on a conditional basis. If within a certain amount of time they can subscribe, I think it's 3 years or something like that. So that, they have that option, I think. But I'd like to see us have a debate about how this stuff is supposed to fit together in a way that makes sure we don't have dead ends in the transmission process.
Right, I'd say our really agree.
Well, I want to thank the panelists for some very thought-provoking remarks, and thank you for hosting it. So, it's my pleasure.